जस्टिस मंसूर अली शाह का तकरीब से खिताब जारी है, बराह रास्त लिए चलते हैं।
Require about 15 to 20,000 judges. So that's another area altogether. So the mindset, the request here is that we must change our mindset. You do not go to court to have far more judges. If we were to look at the international parameters of having 90 judges per million, we have 13 per million. So that would mean that we would probably require about 15 to 20,000 judges. So that's another area altogether. So the mindset, the request here is that we must change our mindset. You do not go to court if you have a problem, if you have a dispute. You try to negotiate, you try to mediate, you try to arbitrate, and if nothing works, God forbid, nothing works, or if a matter requires some judicial interpretation, do you go to court? But you don't go to court otherwise. So let's just keep courts really at a distance. And whenever you look at a dispute, and last time I spoke about the fact that the companies must think of resolving their matters within the company first. Look at their problems within their own inbuilt ADR system, and I think IBA is kind of working with companies on that account also to develop their own ADR system. If that doesn't work, and I was just talking to the Secretary General of OIC Arbitration Center, and he said he added to this equation, and he said, let the companies first resolve it, and if the companies can't resolve it, then it goes to a sectoral ADR center which deals with that sector. For example, if it's a sugar company, then it goes to a sugar sector ADR center because they understand the problem, they understand their sector. So you do that, and then it comes out into the market, into a private ADR center, leading to a court if need be. So I think that kind of a trajectory, that kind of those steps need to be built. And I think we're just very close to that with the support of IB and others. We're heading in that direction. That is just the correct way of doing it. The other point that I wanted to make is that in a system which has judicial congestion and which has a very sluggish litigational landscape, I think it is the right to access to justice, which is a fundamental right. Right to access to justice necessitates that there have to be other routes to resolving your disputes. So when we say, it's traditionally said that right to life includes right to access to justice. Now, access to justice does not mean going to court alone. So I think it is about time that we start considering that access to justice actually means access to resolution of the dispute, a forum where I can resolve my disputes. So where there is such huge congestion, it is now an obligation on the state to provide these avenues, including mediation, including arbitration. So when I say I have a right to justice, it includes mediation, it includes arbitration, and it does not, the traditional notion of having right to access to justice is going to court, I think needs rethink. We need to include this into it. Secondly, I would also request that while we sort of refashioning our mindsets, we must think of ADR will stand for alternative dispute resolution. For a minute, we sometimes think it's a separate little system on the side. These are the courts, and then there is ADR, and should we go to that side? I think that also requires a little rethink. I think ADR or all these other avenues are complementing the justice system. They're part and parcel of the justice system. So to think that ADR is yet some other entity outside the justice system would be wrong. The justice system provides multiple avenues to decide your disputes, one being the court, but there are other avenues also. They're part and parcel of one big justice system. And if we were to think like that, that makes things far more clear. It is one big justice system, and everything complements each other. So my request would be that we must change our mindset and start looking at taking our disputes to on the side. No, it's not. It's just one big part and parcel, and we've been now talking about it jurisprudentially also, that it's one big justice system and everything complements each other. So my request would be that we must change our mindset and start looking at taking our disputes to mediation and arbitration rather than rushing to the courts, and the courts should come at the end. And I just want to quote this Sandra O'Connor's, who was from the Supreme Court, who was at the Supreme Court of the United States, and she said going to courts should be the last recourse if there is nothing else left. I think that is the mindset change that we require, because everybody just rushes to court, stay order le lo, ye kar lo, wo kar lo. That's not how economies run, that's not how countries run. Because if you were to look at today, if you were to examine the litigational culture today, it is nothing but bails and stay orders. I don't know, there are lawyers sitting here, very rare would you see a main case getting decided, because there's so many cases, there's so much rush in the courts that they're just doing, quite, work like bails and stay orders. So a country or a nation can't progress on the basis of stay orders and, bails. We need to substantively decide. One other point that I wanted to make, which gives mediation a great philosophical value also compared to, in litigation, you might lose out on a relationship. You might sever a relationship in litigation, because litigation could have any sort of results that. But in mediation, you keep your relationships, and that's what I wanted to add. That we must think of a communal relationship must always stay and should not go away. You also realize that litigation has its own pitfalls. Lawyers are sitting here, and you understand that adjournments, strikes, very frankly, we talk about this amongst ourselves, that these are very chronic problems with litigation. So fixing litigation.
जस्टिस मंसूर अली शाह का तकरीब से खिताब जारी है। न्यूज़ स्टूडियो से फिल वक्त